I hope this is streaming live. And I am going to go to LinkedIn. I've had a few little glitches going on.
Mm-hmm.
And of course, it's not streaming on LinkedIn. Well, we'll do the best that we can. And I know it should be, and I think I know why, but we will work that out and we'll have a recorded version, hopefully.
Okay. No problem.
Okay. Welcome, everybody. This is Howard Klein, and today I'd like to welcome you to our podcast. I will be interviewing Brent Clinkscale, who is an independent arbitrator and mediator with over 25 years of experience. He will regale some of his most interesting stories as a neutral and give us his top tips. He is also the founder of Clinkscale Global ADR based out of South Carolina. My name is Howard Klein. I'm a mediator and arbitrator and a California licensed attorney of over 46 years. I'm the founder of TKG ADR Mediation and Arbitration Services. While having a broad-based business background, a significant portion of my law practice has been in commercial real estate and commercial landlord-tenant matters. A more detailed bio for both Brent and I, excuse my itch of my nose, can be found in the comments section of the social media channel that you are viewing or listening to this podcast. Now, let me move on. Brent, hi, how are you doing?
Hello, how are you?
I'm fine. Let's start out with, and we're going to move pretty fast, start out with some of your more interesting, we're going to go through 3 of them, ADR stories. And if some of the listeners don't know, ADR means Alternative Dispute Resolution. So take it away. Let's go to your first story.
Well, I think my first story is one of my most recent ADR experiences, and that's in speed mediations. I think they're a great tool for any company or anyone who has a group of cases that they want to try to get settled. And what's so interesting about the ones that I have done is there are a certain volume of cases that you want to do over a short period of time, say 2 days, and you want to get maybe 15 cases settled. And so you want to move those cases on the hour from one to the next. And I think the technique that really works is what you do before you get to the speed mediations, because you want to make sure that the parties have embraced the system and the attorneys have embraced it. And if that's the case, and then you have sort of the right timing, a lot of times the timing is towards the end of the year, because you have a situation where everybody's, some companies want to move these cases off their books, and others are wanting to get something settled so that maybe they can potentially get some money in their pockets.
Well, is kissing allowed?
Excuse me?
Is kissing allowed?
Absolutely. Anything that where the parties come together and they embrace the system. And it seems like if they want to kiss, that's a good thing.
So speed. Now, these are mediations? I'm
These,
assuming.
these are mediations.
Yeah.
And one of the interesting things about it is because it sort of embraces where we are now with technology. The ones that I have done, you have some lawyers and parties who come to the venue in person. Others will appear over the screen on Zoom, and then you might have a combination where the client may be on Zoom because the client can't get there, but the lawyer is there in person, or the other side it can't get there, a bit because they're in another state or even potentially in another country. But you can bring them in the Zoom, and you've already done your prep work with each of the parties, with each of the attorneys, talking to them to see where they are, to make sure their mindset is right and coming to this process and willing to try to get the case done. And then you want to make sure you have pre-mediation statements for the mediator. And they don't have to exchange those statements, but you want to make sure that you're up on where the parties are and what they think is sort of the optimum positions in their case. And you want to make sure those mediation statements are not too long, that they, so if it's better, it's easier to put something in 2 pages than it is into 15. So
Well, I'm trying to think of the benefit. I can think of the benefit of something like this, but how does speed mediation, so to speak, differ from a regular form of mediation as a practical matter?
well, I think as a practical matter, when I come into a mediation, normal mediation, I don't necessarily think that the parties will settle on that particular day, especially if it's a very complex case. I want to try my best to get it settled on that day and work hard on that day or in the several days that you have to do it. But it may not. So what you're doing is you're building parameters. You're building parameters. You're sort of setting the stage to that the parties may come together later, and you want to make sure you can resolve as many issues between them in the period of time that you have, whether the case settles or not. And then you want to make sure that you're available after that day or after that 2 days to come back in and keep talking to the parties to get to common ground. So I think that's the difference. With speed mediation, sort of the parties are already there and wanting to get it done. They're not looking to have necessarily big presentations of their case. They're really ready at that point to get down to the nitty gritty.
Yeah, and I would think that would be the benefit. I would assume that the parties and or their attorneys are not going to a speed mediation unless they're looking to settle pretty quickly.
Yes, I think so. And sometimes the parties may embrace it more so than the attorneys.
Yeah.
The parties they're ready to get this done. They're ready to maybe potentially stop paying attorneys' fees. They're ready to sort of get this case behind them. And if it's a business, the business is willing. They're ready to get this case off their books.
Yeah. I don't know if you're prepared to answer this question. Here's a little curveball. And because I'm going to be doing a separate podcast on this issue. The difference between resolution and settlement. What is your opinion, if you believe that there's a difference?
A resolution. Well, a resolution of a case may not have a settlement. A settlement implies that there's been some type of exchange, maybe of value between the parties. And I'm not necessarily talking about monetary value. It could be something that they're going to do a certain amount of business beyond this point, or they're going to exchange something else that has nothing to do with money, or they're gonna sort of take this case off the docket in order to try to get their businesses to keep doing business together. So that's what you imply when you talk about settlement.
Yeah, my take, yeah, and settlement, as you say, is what we call consideration. The
Yes.
parties are giving something up. All right, and there's nothing wrong with settlement, but to me, when telling a party and drawing the distinction between settlement and resolution, settlement has the implication that someone's giving in. And in order to resolve a dispute, particularly in mediation, that doesn't have to be the case. You don't
It does
have to
not.
be giving something, away, giving in. And it's not giving in. And the whole idea, in my opinion, of mediation is that you both get something rather than someone giving up.
Well, the parties may even agree to resolve it by both sides walking away because they feel like they've been in this too long. They want to just keep the status quo and walk away. That's a resolution of the
Yes,
case. There's not necessarily a settlement to be had.
and you're absolutely correct. So why don't we go on to the second story?
Well, I think that the second story would be dealing with foreign clients who have both federal court litigation and arbitration, and have the potential of mediating both of them, and through different mechanics, through the court mechanics of mediation, but then through the private mechanics of mediation, and being able to have them embrace those concepts. A lot of foreign clients really have to embrace the concepts of what you're doing in U.S. federal court in the first place, because they come to it sometimes with a lot of trepidation. And so you want to make sure that you can explain that and the possibilities and the risk and what's really going on, and really have them understand the process. The federal rules of evidence, and just the federal rules of civil procedure, and how we need to proceed in this case. But then there are other mechanisms there. Most scheduling orders in the court will have some type of dispute resolution mechanism, whether that may be saying you can arbitrate this as an option, or you can go to mediation, or you can just get someone to try to get the parties together to find common ground. Uh, I think explaining that and having to explain that to foreign counsel or even foreign parties when they're actually your client is really can sometimes be a challenge, but it also makes you get to the basics of each of those mechanisms: mediation, arbitration, and actually litigation, so you can make sure they understand where they're going and the benefits of each.
Your Do you like practicing international arbitration?
I do, and I have I like the differences sort of between the civil law system of doing things and the common law system of doing things. I know that the civil law system is more, rules based and not as sort of got you as our common law system. But I've had a very interesting and good experience in watching barristers who actually have just a really exacting, exquisite, and a lot of times you don't use the word exquisite when you talk about cross-examination, but I thought that their cross-examination was just so exacting and exquisite, the way they approached it in some of the international arbitrations, is sort of a difference from our system. And I think it's a difference that it's a good difference, but I think it's a difference that a lot of our practitioners can learn from.
I'm going to step back a second in order to clarify something. You referred to civil versus legal. Are you referring to civil?
I was talking about civil law systems versus common law systems,
as in the French system.
as in the European system versus the American system of, common law, of the judge-made law, as opposed to statutes and regulations, as more of a civil system. And the common law system is our common law system is made up of juries and judges, and the splits of the judge ruling on the law, but the jury actually ruling on the facts of the case, and the civil law system is different from that.
Yeah, from my understanding, here in the United States, I think there is, except for one state, all of the states follow the common law system, which came down from the British, and one state follows the civil system, which is Louisiana, which really came down from the French.
Exactly.
And I'm trying to think, but yeah, it's. I'm not that familiar with French law, but it's everything is in writing. Everything is statutory, and it doesn't come down to judges' interpretation, or at least it's not supposed to.
Right. And then in the common law system, it's the judge's interpretation, of course, and then the jury makes the ultimate decision. In our system, when you have a jury case, of course, you can have a
Sure.
case given to the judge.
Well, but even when you have a jury, the judge is the one who makes the decisions on the law,
Absolutely.
and the jury makes the decisions on the facts. So, for those
But-
lay people out there,
The jury has to apply the law as given to them by the judge.
right. And I think most people are kind of familiar with that system that they see, in criminal law cases, et cetera. And well, here are the judge's instructions. And for anybody who hasn't, my jury trial, I'm trying to think. It's like a civil jury trial. One that I had was like 50 pages of jury instructions that I'd have to give to the judge, and then the other party gives all their jury instructions, and the judge tells you what it is that he's going to actually do.
Well, you don't have to give any jury instructions to the arbitrator.
Yes, that is true, which is an advantage
That's one less
of
thing.
arbitration. Absolutely. Let's go on to story number 3.
Okay. I think story number 3 for me, and I'm looking at a couple of notes I had for to actually.
You're entitled to a cheat sheet.
Okay. I think let's see, the last thing that I had was I've had a number of virtual arbitrations, and I am really always amazed at how efficient they can be, but also how useful they can be, especially when you're trying to schedule individuals who may be witnesses from out of state or from another country, etc., because you can always find a time to get them to testify through technology. And I think that works very well. And I'm always amazed at the nuances that you have to pay attention to. Whether the witness is in the room by themselves, whether you can have a view of the room, whether the witnesses are having some type of conversation while you're proceeding with the arbitration. All of those nuances of, what's in your background, making sure, as we did with this podcast, that there's no noise coming in from other directions, and actually to make sure that the witnesses are not using some type of notes, or if they have some documents before them, that the lawyers understand what those documents are.
Yeah, that would be an issue. Talking about that issue, with witnesses having documents in front of them that they're referring to, I generally don't find that to be as much of a problem because you can tell. You can from the if it's a video, if it's a telephone, that to me is problematic. But if it's video, you can see when someone's glancing down or looking somewhere else, etc., rather than looking into their camera. And often you can tell if someone else is in the room because you can see. I think most witnesses who will do that will look aside for some sort of approval with someone else in the room.
I think that's a fair point, but a lot of lawyers don't depend on that. They want the arbitrator to make an affirmative statement or ask the affirmative question of does the witness have anything before them? Does the witness have any documents on the table? Can you have the camera view the total room so to make sure that there's no one else in the room with the witness? Or if there is, who is that person? So a lot of attorneys, and I think very good attorneys, will have the arbitrator do that at the beginning, so they won't have to make a judgment call as to whether somebody's there or whether the witness is looking at something.
Have you ever had an experience where someone said that no one else was there and there were no documents, and in fact they were?
I have not had that experience because I usually try to cover that at the beginning. I also, the lawyers I've dealt with in these virtual arbitrations really have been very good at understanding that the witnesses not to have any documents before them that they are relying upon for their testimony, unless those documents are presented into evidence and you're questioning the witness about those documents.
In some of my mediations, having documents in front of a party is not an issue because they can have whatever they want in front of them. But we've had instances in which they have indicated to us no one was there. And in fact, as it turned out later on that someone was there, someone else was with them.
Well, I've had arbitrations where you have two people in the room and those individuals are both witnesses. And one witness they're testifying from the company headquarters, or they're testifying from a plant, a manufacturing plant, etc. So they may be in the same room where the camera is, and we're sort of moving, very efficiently through the witnesses. So they're sitting in the same room there together, and both attorneys have agreed upon that, and they're okay with that. The problem kind of comes in when they are talking to each other when they're not testifying. So you don't want that to happen, and you have to admonish them that is not supposed to happen.
Well, in-person trials, I've always insisted on witnesses not to be in the courtroom.
Yeah, you practice sequestration. You don't want them to be in the room with the, so they can hear the testimony of the other witnesses.
Yeah, well, you would think that really sharp people, if they were in there, would be listening to the other witness and would be learning from that and would even inadvertently modify their testimony in order to match the other person. I could see someone just doing it going, without purposely changing it. Although I would imagine there's plenty of people who aren't even smart enough to listen, they don't pay attention, etc. But I'm just very uncomfortable. I don't want any kind of testimony tainted at all.
I think that's tactical by the lawyers.
Yeah.
I think some lawyers tactically want the witness in the room where the other witness, even if they're on the other side, is testifying, because they want to, question, if they can, that witness is about that testimony. So I think it's tactical. It depends on the lawyers and what they want and what the actual presider, whether it's the arbitrator or the judge, will do.
Yeah, yeah. Well, that's part of the beauty of arbitration is that the parties can agree to a lot. You don't have to stick to necessarily court dictated procedures.
Yeah.
You sit down and you say, okay, guys, how are we going to handle this? Here's the basic rules. Now, what do you want to modify? What do you want to agree to? And how do we speed this up?
Well, that's one of my tips.
Okay. Well, then why don't we do this? Instead of doing that, let's go to the next scene, which is top tips for arbitrators, top tips for mediators, and top tips for parties.
Okay, my top tips for arbitrators would be to remember that this is arbitration and not litigation, and that you just need to kind of make sure you emphasize that in your mind, but also in the attorney's mind, because you have the obligation to drive the efficiencies of the process, and the process is yours, even though it's driven by the parties. And I think one of the things you talked about is notice that we do use the word the process is driven by the parties. Now, it's not necessarily controlled by the parties. You're supposed to control it as an arbitrator, but it is driven by them, and it should be, because they've agreed to come to arbitration. And the more that those parties can agree to, I think the better for the arbitration. And they ought to have some leeway to agree to certain things, even though, and I think my third tip would be that the arbitrator has to remember that the parties got the arbitrator to make a decision. That's why they're in arbitration, because they want the arbitrator to make a decision. And one side may not like the decision that you make, but they are there for you to make the decision so you can move that process along.
And what about your top tip for the party?
My top tips for the parties would be to make sure that when they are, and a lot of parties don't understand the difference between confidentiality and privacy. And they may not understand, and this is one that I think parties need to understand, is that arbitration is not necessarily by the rules confidential. You have to check those rules to see if the whole process is confidential. And if it's not, the lawyer needs to get a protective order or confidentiality order. Now, as far as me as the arbitrator, everything that I do, of course, is confidential. But as between the parties and what they do and talk about the process, it may not be confidential. And that is a very important tip that the parties need to understand, and the parties need to know. You need to check the rules. It may say in the agreement that you are to have a confidential arbitration, and that works. But you may want to back that up with some type of protective order that all the documents, etc., the evidence, etc., in this arbitration are confidential. That's always a good thing for the parties and good for the attorneys, because you need to understand that, under all rules, under all systems, is not automatically confidential.
Sorry, got distracted here. It's not supposed to call me. Okay, so I think that's a great point. I don't know. As an arbitrator or mediator, we talk about confidentiality, we talk about privacy, but when it comes to arbitration, it's not what most parties believe. And there are so many agreements that have arbitration provisions in it that don't address that issue.
They don't.
Oh no, and it's scary. If you want to stay, first of all, even if it has a provision that the arbitration and the discussions in arbitration, the documents remain private and confidential. If you want to enforce an arbitration, you got to go to court.
Yeah.
And once you go to court, the fact that there was an arbitration is public.
Absolutely. Absolutely. And I think a lot of times when clients have come to me as an advocate and they want to go to arbitration, they're not necessarily thinking about cost, etc. What they're really thinking about is they don't want a public case. They want a private, confidential matter. And sometimes they may say, we don't care how much discovery is done, etc. We just want this particular matter to be private and confidential. Well, you have to take that extra step a lot of times to make sure that it is private or confidential.
That is such a big point, and will be a point that I'm going to be doing probably a webinar on writing arbitration provisions in commercial real estate leases. Mm-hmm. And in review of my older leases, I put in incredibly deficient arbitration provisions. I'm embarrassed to say, but I've been around long enough to have made a lot of mistakes in the past. And in commercial leases, invariably the parties want everything within 2 sentences. Mm-hmm. A 30-page lease is no longer considered a small lease, except unless, of course, you're in New York, in which case most leases are 90 pages. And I jokingly say, well, in New York, it's the first 2 pages are what the tenant gets, and the last 88 pages are taking it all away.
Well, I think with arbitration clauses, what you want to make sure is that you don't put too much in them that constrains the arbitrator.
Yes.
Because you want to have the arbitrator to have some flexibility and to be able to make certain decisions. And sometimes less is better.
Yes.
As far as in the arbitration clause.
Well, again, there's another a podcast that I'm going to do on paying attention to, if you're going to have an arbitration provision, paying attention to the institution who's named in the arbitration clause, because the institutions have different general rules on discovery. And a lot of attorneys are going to be uncomfortable with the kind of limitation that some of the standard rules provide. Of course, the parties can change those rules.
Well, and I think a number of clients today and number of businesses want tiered arbitration clauses. They want in there that the parties have to meet among themselves at a certain point in time, or for a certain point in time, to try to get that issue resolved among themselves. And if that doesn't resolve it, then you move to maybe a mediation process. Right. And then if that mediation doesn't work, then you move to arbitration, because it gives them the steps to try to get it resolved, and sort of has sort of forced procedures in the arbitration clause to get it resolved, especially when you have businesses that are continuing to do business together.
Absolutely. One of my favorite words that I often use in a commercial lease, when a real estate lease, when I'm writing it, is the word reasonable. Mm-hmm. And people go, well, how do you define reasonable? I said, I don't know, but it forces the parties to consider it and try to resolve it themselves. Now, they don't always agree.
That's the reasonable is another sort of word like the phrase good faith. So they kind of walk hand in hand, and they have to interpret what that means.
And I like it when the parties, when they have a long-term relationship, are forced to consider that. You know,
I agree.
are we acting reasonably, or do we have to mediate? Do we have to arbitrate? Do we have to hire an attorney? Maybe we should try to work this out among ourselves, because that's the ideal.
Absolutely, and that's a that is sort of the the new thinking in ADR, which is early dispute resolution. I've had a number of clients that come to me, basically hire me to say, "Can we get this resolved early?" We don't really want to walk the path of going to court. We don't want to walk the path of going to arbitration. We want to get it resolved now if we can, to try to build a process to get it resolved now. So we don't have to do that. We don't have to spend that money. We don't have to upset the relationship with the opposing side. So we want to try to get it resolved now. So early dispute resolution is something that is really becoming prominent in our space.
Okay, one last question. I'm actually going back because you pointed out issues having to do with confidentiality and privacy in arbitration. How might that differ from privacy, the concept of privacy and confidentiality in mediation, if at all?
Well, I think mediations, usually court-ordered mediations, and any mediation agreement, you're going to have that they're confidential because and you're going to have, and the courts all support this, that anything really used and said in the arbitration can't be used in court because you want the parties to try to put everything on the table so they can have a good discussion and try to get the common ground and settle a case. So it is a little bit different. Mediations are generally confidential. They're generally confidential whether it's a court-ordered mediation and or there is a mediation agreement between the parties.
Great. Do you have anything else to add? Mr.
No,
Wealth of Knowledge.
well, I'm so happy to be here. So happy you asked me to be here, and I enjoy talking about ADR and enjoy talking about mediation. Enjoy talking about arbitrations, the combinations of both, and also this idea of helping parties really to resolve their dispute, because they're not there to the paid lawyers. They're there to do business and try to have a productive business. And I think it has really helped. I've done a lot of pro se cases, and I've done a lot of consumer cases. And I really think that in that process, arbitration really helps and really works because it's not a situation where because the pro se person or the consumer person has done something, they've missed something, so they're going to get thrown out of court on a technicality. They get to be involved in the process. And I think if you look at the AAA rules and the sort of information that they give to pro se litigants, pro se claimants in arbitration, it's really a wealth of knowledge of how to proceed with your case. So they really need to, if they come into the situation of arbitration pro se, especially under the AAA, they really need to look at the information that the American Arbitration Association gives them. And they do a great job of giving information in reference to consumer cases, etc.
Yeah, it's you got to know the rules, not just the mediators and arbitrators. You really have to, just like you would in court if you're an advocate, you've got to know the rules. And it only takes one instance in which you don't know the rules that can come back and sting you. It's like, maybe I should read the rules. So yeah.
The arbitrator is not there to help you to do your case. Okay. So,
Which comes to my last tip.
okay.
Prepare, prepare, prepare. Those are three tips. I just, in so many instances, I've found parties and their attorneys, who we refer to as advocates, are just simply, they don't understand the process
Right.
and they don't prepare. I mean, it goes without saying to prepare in an arbitration if you're an advocate, but in mediation, you should be prepared too.
No,
And
I agree.
oh gosh, that to me is the most important thing, is before you even start, prepare.
And for the arbitrator, you got to always review the rules, even if you think you know the rules. Look at them again before you go into that preliminary hearing. Go back over the rules and actually go back over the agreement between the parties,
Yes,
especially the clause that actually brings them to arbitration. You can't know that well enough and look at that often, even through the case. And so you have to make sure that you're reviewing the rules every case. It may be the same rules. You want to look at them again, and you want to make sure that you go over that agreement again between the parties.
absolutely. Well, I'd like to thank you. You honored me for being on this podcast. I hope to have you again anytime that you're interested in expressing yourself. Feel free to give me a call and we'll set something up. And if there's on the screen now, you can see how to get a hold of Brent or I, either through our LinkedIn or our websites. I have to really redo my website. And is there any other way that you'd like people to get a hold of you? They could figure out how to get a hold of you just going to your website.
Absolutely, absolutely. Or LinkedIn, they can contact me through LinkedIn, and both are appropriate, and I respond to both.
Yeah, and if you're watching this video and you like it at all, please feel free to subscribe on YouTube, and I'm not sure, I guess follow me on LinkedIn, or follow Brent, follow or connect to him on Brent. Just say, I watched you on Howard's podcast, so maybe he'll say, sure, connect to me.
Well, I have absolutely enjoyed it, and I thank you very much for inviting me.
Well, thank you very much, Brent. That's a wrap. You have a great day.
You
Bye-bye.
too.